I was very interested in the distinction you drew a few moments ago between religion and belief. And, of course, Article 18 of the UDHR is very specific about religion and belief, or indeed no belief. And I'm interested to know what domestic law does, what mechanisms are in place to respect and uphold the position of people who are caught in any of those traps. By example, I met one of the Scottish midwives who lost her job because she didn't want to be involved in the commissioning of abortion, and the tribunal, of course, held against her in the end. She and her companion lost their jobs as a consequence. I mean, are the mechanisms sufficient for someone in that kind of position to be able to explain what their beliefs and their conscience tells them?
Well, it should be, certainly, but it will depend. I mean, first of all, the Equality Act, Section 10 of the Equality Act, is capable of encompassing both people who have religions, established religion, religious belief, or a philosophical belief, which can be a very broad thing, like belief in climate change, belief in communism, belief in gender-critical views, or whatever. Being, pro-life would be, I'm sure, fall into the same category, although don't quote me on that. And it also covers lack of belief, as you mentioned. So you can bring a claim on the basis that you were discriminated against because you don't believe in a particular thing, but that particular thing has to be a philosophical belief for the purposes of the Act. But the question of whether or not it's acceptable for your employer to subject you to a detriment because of that is a different question, and it will depend on the work. So, and what's necessary for your work. So with Mrs. Liddell, who is supposed to be marrying people as a registrar, the circumstances of the job had to be taken into account, whereas with Mrs. Oweda, who was just wearing a little cross when other people had their religious symbols, and the proportionality exercise that has to be applied, which takes into account a very wide range of circumstances and is a very, very nuanced analysis, will have different outcomes in different cases. So it's impossible to say, a nurse and a midwife shouldn't be made to be involved in conducting abortions. It's impossible to say that what would be the outcome had you had a different judge on a different day, frankly.
Yes, and just picking up on that, how an individual articulates their belief or lack of belief is crucial. Yes. It can be the difference between winning or losing their case, because that's the starting point. You identify the belief or the lack of belief, and then the court or tribunal has to consider in a direct discrimination case, well, was the reason that you were treated in the way that you're complaining about because of the belief that we've just identified? And so, a difference in the way that you articulate the belief can affect your prospects of going on to prove your case. And we spend quite a lot of time in the employment tribunals and in the courts articulating the belief, when really the focus in most cases is actually on what was the reason for the treatment that you're complaining about. And so there is a risk of being, I don't want to say sidetracked, but of too much emphasis being put on a sort of generic sense of, well, this is a belief or this is a religion, and not enough emphasis on what was the reason that you've been treated in the way that you've been treated.
That makes sense. Thank you very much. So thinking about Articles 9 and 10 of the ECHR, are there any improvements that we should be making to domestic law and the mechanisms in order to do the things that you've just said? And perhaps Professor Wintermute would like to come in on that as well.
Thank you for your question. I think we need to take a look at inconsistencies in UK law, of which there have been many over time, especially in anti-discrimination law. So it was legal to discriminate on the basis of religion in Great Britain for many, many years, and legal to discriminate on the basis of race in Northern Ireland, and it took a long time before that was fixed. So at the moment, the anomaly is that we have a prohibition of discrimination based on political opinion in Northern Ireland, but that does not appear in the Equality Act. Although we were forced, because of the Redfern versus United Kingdom judgment of the European Court of Human Rights, to create a category of unfair dismissal based on political opinions or affiliations, which were, it was an exemption from the minimum employment requirement before bringing the claim of unfair dismissal. And so that's partial protection, but that could easily be made more general in the Equality Act. And this would really solve the problem of what is a philosophical belief. So I think the intent originally, you'll find the phrase religion or belief in Article 9.1 of the European Convention on Human Rights back in 1950, but it was inserted in the context of conscience and religion. So they had in mind conscientious belief. The EU directive said religion or belief. When the UK implemented it, we said religion or philosophical, or religious or philosophical belief. And that's been the debate ever since. What is philosophical? And I would say any political opinion can be shoehorned into a philosophical belief. So instead of, and this is where we risk having cases fall through the cracks and ending up in the European Court of Human Rights, failure to protect an Article 10 freedom of expression right. So I think it would be better, it would offer more general protection if we would just insert political opinion as a protected characteristic. Now, I was just thinking today about, does that require any additional exceptions? I don't think so, because we don't have any special ones for religion or belief. Basically, if it affects your ability to do your job, that would be an exception that would apply. And just returning to the Ngole and Forstater cases, that's always the question, how has it affected the workplace? So you had students comment, well, that was a university, he was not actually an employee, but he posted comments on Facebook that some people found offensive, but he did not repeat them in the classroom. He did not discriminate in any way against anyone. And the same was true in the Forstater case. The employment judge assumed that she would necessarily harass a transgender co-worker because of her beliefs. But this had never happened. She didn't have any transgender co-workers. So that's a thing that always has to be borne in mind, both by the employee expressing the belief. So there's a huge difference between posting to Facebook or tweeting and expressing your opinions to your co-worker at the next desk. So that's where a harassment situation could arise, if you're forcing your opinion on someone else.
So at the moment, if somebody lost their job, if somebody was sacked and was actually told by their employer, I'm sacking you because you're a member of the Labour Party, for example, in order to get an anti-discrimination claim, they would need to shoehorn that into philosophical belief. Is that right?
That would be,
But you're suggesting, Professor, that perhaps we should have political opinion then separately. Please tell me if I've got this wrong, because
party politics doesn't count.
No, but
party politics doesn't come into.
You couldn't shoehorn that into philosophical belief.
You could,
Yeah.
because the Section 10 deals with religion or belief, and belief is sufficiently broad and expansive in scope. There are criteria for your belief to be judged by, but you have to demonstrate, for example, that the belief that you hold informs the way in which you live your life. So, if you like, a passing reference to the Labour Party probably wouldn't amount to a belief protected by Section 10, but lifelong membership and periodic campaigning or activity in local politics would probably be sufficient to establish the necessary belief.
I think,
just
to jump in there, I think
I don't want to open up a rabbit hole here, but just quickly Akua and then back to...
Okay. I think the difference is what you have to show is a belief rather than an allegiance. Yeah. So you'd have to show that you had like if you were to say I'm a socialist and that's why, and I have this lifelong belief in socialism, then fine, that would probably work. So there's been a case on communism where somebody was found to have a protected belief. But saying I'm a member of a political party would probably not do it. And just on Rob's point on political opinion, I'm not convinced that would be a good protected characteristic, but we'll just note that in Northern Ireland, as far as I'm aware, they have political affiliation as a protected characteristic.
Yeah, Helena.
You'll remember that during the height of the pandemic, there was a great debate about workers in the National Health Service who might be refusing to themselves except the inoculation against COVID. And there was great concern that there was a sort of anti-vax group of people who were not prepared to take a vaccination and therefore might be much more likely to have an impact on the patients that they were caring for. If someone were, I think that there was the unions and so on sought to kind of hose that down by getting people to generally agree or move people away from particular roles. But if someone were sacked for refusing to, because they said, I don't believe in vaccination.
Shouldn't be in a hospital.
No problem. That's runnable.
Yes, I mean, and there have been cases at first instance where individuals who have refused, in those sorts of circumstances, who've refused the COVID vaccine and therefore not been able to return to the workplace because it's a requirement of their work to be vaccinated. Those cases have been brought. They haven't been run on the basis that they are anti-vaxxers. There's generally, because lawyers are involved, there is a sort of rather more nuanced argument as to what the belief system might be. But it's perfectly possible to run those claims. And ultimately, whether that individual wins or loses, it depends on the evidence that they can pull together to demonstrate that whatever their employer might say, the real reason was their belief.
But the real difficulty, this really illustrates actually what the difficulty is with these cases once you get into tribunal or court, because the real focus on a case like that will be on whether or not it was legitimate for the employer to exclude the person from the workplace. So the employee will be wanting to make their anti-vax arguments at length before the tribunal, and the employer will then be arguing about why vaccinations were appropriate. So you end up having a political debate in tribunal. And a lot of these cases get sucked down that rabbit hole. Forstater at first instance went down that rabbit hole. And you know, when you see employment appeal tribunal judgments, they often start, the Forstater EAT judgment started with a full page on how they weren't getting sucked into it. And it was like a disclaimer that they didn't have any opinion on it. But it's very, very hard to stick. So these sorts of cases are very good cases for activists, and they are a very good platform for activists, but it's very difficult for judges to navigate their way through without coming down one side or the other. And actually, fundamentally, in the end, there's no way out, in my view, for the judges to do that. But to do that,
there is a Supreme Court authority, I think, the name escapes me for a moment, which says that it is the job of judges to make these difficult decisions. They have to carry out an evaluation exercise. They have to weigh the evidence, and ultimately they have to decide whether an interference with a fundamental right is justified. And so acknowledging the difficulty of the task, but saying to judges, you cannot shirk it, you must do it. And then the way that the law has developed requires that assessment in many cases. It requires what we lawyers describe as a proportionality assessment. So weighing, the arguments on the one side and the arguments on the other, looking to the employer to say, well, why did you do this thing? And so if an employer is saying, well, I in the hospital example, it was necessary in order to provide protection for patients that staff members were vaccinated. So that's the legitimate aim that the employer has identified. The question then is, well, is it justified? Is it an appropriate and proportionate response to that to say to this employee, well, if you don't have your vaccination, we will dismiss you, or we will remove you from your job? So it is a very difficult evaluative exercise, and the cases that are brought generally have to engage with that challenge.
So if J.A.G. Griffiths was still alive, he would be having a field day with the politics of the judiciary in this area, because there are value judgments being made.
Yeah, absolutely. Although, again, in the jurisprudence, it's often repeated. It's not for the courts or tribunal to make any comment or assessment on the merits of a belief or on the credibility of a belief. It's simply to identify whether or not it exists in accordance with specific criteria. Yeah. But there's necessarily a value judgment and some kind of subjective exercise.
Yeah, at the next stage.
Yeah.
Professor.
Yes, I could refer the committee to a 2014 article in the Modern Law Review, which I published. The title is Accommodating Religious Beliefs, Harm, Religious Clothing or Symbols, and Refusals to Serve Others. And I think that's the overarching question, is there any harm to others? And that's what distinguishes skull caps, hijabs, turbans, crosses from non-refusal to get vaccinated, when you may pass on a virus to a patient.
The harm test.
The harm, yes.
We'll make sure that our team get that citation for that journal article. Sorry, David. Were you...
Chair, I think it was a very good excursion down the rabbit hole, and thank you very much. Given that one of the tasks of the committee is to make recommendations for improvements, I was asking about the mechanisms, not now, but if afterwards, if perhaps in writing to the committee you have any further thoughts on what improvements might be made, I think we'd be very open to hearing that.